Good morning. Sorry we're running a little bit behind, but I think we'll make up some ground. So I'll go ahead and call the meeting to order. I don't want to put you on the spot, but one of you want to make a prayer? Judge Gunner, will you bless the meeting?
Yes, sir.
Thank you.
Please join me in prayer. Heavenly Father, we thank you for this day. We thank you for your love for us. We thank you for the positions that we hold down here and the ministry that we have here. Pray that you give us wisdom in doing your will, and that you bless those that have come here and bless this time that we have. In Jesus' name I pray. Amen.
Thank you. All right, we'll start with our friends at the Supreme Court. How are y'all today?
Great, Mr. Chairman. Thank you for having us.
You betcha.
Mr. Chairman, I am here on behalf of the court and the Judicial Council, returning the favor that the presiding justice paid me at your last committee meeting. He is actually out of town today, and so I was at a conference last time, and he got my share, and I'll do my best to do his part with you today.
Some big shoes to fill. He did a good job.
It's a pleasure to present to you the Supreme Court's budget request for the fiscal year 2026. I will try to follow, I believe, your track sheet numbering system and start then with a 10.1.1, which is an increase, a one-time increase for public electronic records upgrading. This is similar to what you heard during the amended budget process. Our understanding is that there are some federal regulatory schemes about ADA compliance, primarily for those with visual impairments on websites. That may be that rule has changed. It may be that there's a statewide solution, but to the extent that we need to be compliant, this is our cost of compliance for our docketing system and websites substantially less expensive than the docketing system. 10.1.2, this is an increase, a request for increase in recruitment and retention pay for our attorneys and our professional staff. We have some significant disparities. That line is for senior staff and select positions, and then the 10.1.3 is a partner to that, and it is for a broader subset of our employees and staff. But again, the same sort of thing is for recruitment and retention. We have been in communication with your staff. We've had substantial turnover at the court, and we continue to want to make sure that we both recruit and retain high achieving and high performing employees. 10.1.4, 5, and 6 are all what I sort of call the you told us what to do from an increase standpoint. So this is the DOAS, the TeamWorks, and the rent assessments that we're just passed directly to us. We turn around and put it down on our list. 10.1.7, this is obviously the biggest portion of our request. This is the funding for the judicial pay reform proposal as it relates to our court. I will note that neither our court, Statewide Business Court, or the Court of Appeals had the benefit of the language that you're currently considering when we turned in our budget requests. So that number, staff to staff, we want to do some truing up. We're highly confident that the net of that is negative to the net request. So you're not going to have to find money, but we want to make sure that we're actually accurately capturing exactly what the legislation you have. We think we have those numbers, and we'll provide them to staff from our staff when we're certain that we've got it exactly calculated right with that legislation. And then also similarly a pass-through, but a little bit unique to our posture, is 10.1.8. And this is the trooper detail that is assigned to the Chief Justice. And again, this is a number that we received from DPS as a part of having that detail serve within our court body. That's the list, Mr. Chairman, and certainly I'll stand for questions or sit for questions, as the case may be.
Well, thank you for that presentation. We do have a question. I just want to make a quick update related to 1011. We did look, this is related to the ADA compliance for the website. We did look into the state process, and I think GTA offers things, but it's an analysis process to go through to see what you actually need. So I know you asked for it. I can't remember if you appeals court asked for it in the amended budget as well. We did pull it while we analyzed that more. I don't think we have any other option right now other than to fund it, and to go that path. And that's already based on a quote I think you already sent to us from your vendor, right?
Yes, sir.
All right. We'll go over the question. I'll have some comments in a second. 16.
Thank you, Mr. Chairman. Thank you, Justice. Could you talk a little bit about the turnover percentage among what you would consider senior staff? And also, I'm curious the range of salaries between those that start and what someone can hope to earn if they make it to that senior status.
I can, thank you, Representative. I can talk a little bit, and I may defer to Mr. Serratu, who's our fiscal officer, for the specifics on the range piece. We have, of staff attorneys, which is sort of the core function, we've had 72% turnover since 2020. And so we've seen a lot of turn in those roles. We have provided data to the committee's staff about sort of the nature of those. A substantial portion of those have gone elsewhere in government. Some have gone to private practice, and then probably a little over a third have retired. And so we also have another roughly half of our staff that is within a 5 to 10 year window of what you would project as a retirement age. I mean, obviously we don't force anyone to leave, but we sort of looking forward, we have to be prepared for that. And so we anticipate that we will, even in addition to sort of ordinary sort of attrition and maybe other government entities, that we'll have substantial retirement in that window. And I don't know, you got our sheet.
The average for the court staff.
Okay.
Yes, this is the average.
This line is here. So the average for our staff would be 120 for the attorneys, 123,791. The range of that, I think the high point for a staff attorney is in. I'm not looking at it right now, but is in the.
I don't have the.
It's about 130.
I think it's 130. It's in the 130s. That's sort of where it caps out. I think 135 is the number I have in my head, but we'll certainly provide the scale to staff. Yeah.
I appreciate the information. I just wanted to say kudos to y'all for. I mean, 70% turnover is awful. It's hard to think of any law firm in the city or any business performing at a high level with that kind of turnover, and y'all turn out good work, and I just appreciate what y'all are doing with so little, especially knowing what attorney salaries have gotten to in the metro area in particular. It's amazing that you're able to recruit at all, and so just wanted to say thanks, and for the benefit of the committee, that we need to add some meat on those bones. So thank you.
Thank you.
Thank you. I'll go into 1017 a little bit. Tell me what it looks like if we didn't fully fund the raise, but we stepped into it. So say we did it over a couple of years. What does it look like from your staff perspective? Is that something that, or from your perspective, if we didn't fully fund it, but we incrementally stepped into it? That's typically what we like to do. How does that affect what we're trying to do? And
Well, there's two bills now in the legislature. The committee members will likely remember. I'll look and see that you were all here last year. There's one that relates to the Superior Court funding, and then this one, the one that would affect us, is obviously for the statewide court. So our court, Court of Appeals, and the statewide business court. As a practical matter, we recognize that our funding is directed by the legislature, and so it would look, in terms of how it would step in, it would look however however you would indicate or desire to step in. I will just note, for what it's worth, that as of 2025, the National Council of State Courts has updated where we stand relatively as a state. We are 40th in their rankings for Court of Ultimate Review, a Supreme Court, in terms of compensation. We are 30th for Court of Intermediate Review, which is our Court of Appeals. They don't have I don't believe, I've never seen a metric for the statewide business court comparison set, so I don't have anywhere to put you there. The numbers that we have targeted in terms of the maximum authorized, I think put us 21st, and I have it written down, and I apologize, Mr. Chairman, I don't know where I placed it, but 21st and 10th or 11th, if I'm looking at my numbers right. And so that's the range. In other words, if you're sort of looking at our peer group, we continue to lag our immediate neighbor states, not just sort of within the whole set, but our averages in both those are substantially below all of our neighbors. So as a practical matter, if the legislature elects to phase in or step in and increase, I would say that from the logistics of how the budgeting cycle works, the preferable piece would be a full or significant move with a specific date, because that at least gives the individuals holding that position the security that that's now establishing a new floor. The Constitution prohibits reduction in a judge's compensation during their term of office, and so it at least creates sort of some sense of that there's a new floor that's been established. And certainly we can walk through the logistics of how that would come out within the budgetary cycle. I know that last year the House position originally was a full funding of the plan, but in the middle of the fiscal year. Ultimately, that didn't happen. I guess there's ongoing discussion about the end of this fiscal year. That's not the concern for today. But I mean, I would suggest too that there's a step component of that too. That was anticipated last year, but ultimately nothing happened. So.
Okay. Any other questions? Members of the committee. All right. Well, thank you so much for that presentation. I think you're going to jump over to Judicial Council now. Is that right?
Turn over the table, and otherwise I'll just keep right on plowing. Thank you, Mr. Chairman.
This is section 6, page 2. Well, welcome.
Mr. Chairman, I'm joined by Ms. Cynthia Clanton and Mr. Andrew Zoll with the Administrative Office of the Courts. And as I always say, as with my prior presentation with Ms. Barnes and Mr. Sharatu, they are here so that I can answer the hard questions and not make any obvious mistakes. I will follow the same pattern for going through our items on, I believe, your track sheet. So we're in section 6, and we'll start with 6.1.1. This is a request that comes from the Council of Accountability Court Judges, and it is a request for a certification officer position. You will, I think, all realize the expansion of accountability courts across the state, coupled with this Council of Accountability Courts judges gaining new responsibility for our juvenile accountability courts and certifying them, will create a higher demand for them. All of these courts are certified on a every 2 years basis. We have 191 accountability courts that must be tracked. They are obviously, again, all certified on every other year. That represents 56 adult felony drug courts, 43 adult mental health courts, 24 veterans treatment courts, 23 DUI courts, 23 family treatment courts, and 19 juvenile treatment courts. And of course, there are accountability courts in the pipeline, most notably in that juvenile space, as that has become an area where we're seeing growth. So this is literally just the process of certifying. This position is someone who would help us validate, according to the statutory schemes that you have passed and best practices, that we are following what the directions are for our accountability courts. The next item would be a new position, the 6.1.2, and that is for a statewide coordinator position. The function that I'm going to describe for you is primarily being conducted actually by general counsel for the Council of Accountability Courts, because no one else is there to do it, but it has proven to be a worthwhile and needed function. The idea is to try to identify best practices and available resources for accountability courts for their participants in the courts to be able to use it. So job training, GED tutoring, transportation, literacy programs, so that we're not reinventing the wheel around the state when we have a good function. And if we have an identified need within an area, somebody is helping to coordinate the resources within those communities, so that we're doing that hopefully in a more coordinated function. So that would be the request that you see on 6.1.2. That's a $75,000 salary range within the benefits and fringe.
I'm going to ask a couple questions just related to those instead of us.
Yes.
A little bit longer of a section. So on the certification officer position today, I know there's so many certification officers per accountability courts. What is it today, and what will it be with this new office?
We have, on average, I'm looking through my notes. I have seen that number, and I'm trying to make sure.
I feel like it was like one for like 50 or 6, somewhere in that ballpark. Certification.
I believe there's three certification officer positions currently. This would bring that total to
324. That's what. Yes. That's
And there's how many courts total that accountability?
191.
Okay. All right.
So the average review cycle, by experience, is approximately 5 business days to complete an audit or a certification review.
And is that?
Sorry, I just got the number you're looking for. It's 64 accountability courts per staff member currently.
Currently, and it'll go to 40-something, high 40s or something like that. Okay. And then for the 612, the service statewide coordinator position, there is one position that travels throughout the state to the different areas that need coordination. Is that right? So if this is related to, like, if you need help. I know you said about workforce and getting jobs, but someone who's really coordinating those efforts locally in the districts to say, or circuits, I guess, for to say this is working with the technical schools, working for finding housing in different areas, especially ones that are struggling to do that.
Certainly, Mr. Chairman, housing, it remains, sort of consistently at the top of the list in the accountability. Well, in many areas in Georgia, in the accountability court space is no exception. So yes, I do think that it would serve the state, and I would expect that there would be a traveling component, but it is a statewide coordinator in the sense that there would also, I would imagine that they would do a substantial amount of work that wouldn't require physical presence, but helping to identify and connect people to existing resources, or identify gaps in resources and help to recruit people to fill those gaps. This would not be a service provider role. It would be.
And you don't currently have a position like this today.
We do not. This is
it's really done by the local judges.
Yeah,
and
local
staff.
judges. In terms of how the council is doing it, like I mentioned, their general counsel is just sort of ad hoc doing it because it needs doing.
Okay.
But yeah, we don't have a role. So I think there's probably the local judges, the local courts are doing it at their level. and I would be shocked if they aren't sharing best practices across, courts and circuits, because that's what they do pretty much in every area. So I don't have affirmative knowledge that they are, but I can't believe that they aren't.
Thank you. Any questions from the committee on 6.1? Okay, go ahead. Thank you.
Thank you, Mr. Chairman. Turning next to a request that comes in Section 6.2 from the Georgia Office of Dispute Resolution. This is a request both for position funding and maintenance of a software system request. Currently, the Georgia Office of Dispute Resolution does not receive appropriated funds and has not since 2011. It has been funded by its sort of own dues schedule and system. Those funds have been diminishing over time. I mean, in other words, decreasing the balance, and are looking for the support for a singular program manager position and then funds for the statewide dispute resolution software system that they use. So the total of that is $168,950 that you see on your 6.2.1. In the past 5 years, we have seen an increase to 37 court ADR programs across the state, serving 111 different counties. This program manager would oversee daily operations, stakeholder engagement, program development, and then enhanced support for the registered neutrals, the individuals who are actually registered ADRs in Georgia. And so that's the gist of the request there, Mr. Chairman. I'll certainly, if you have questions about that before I move to a different part of our.
Yeah, are there any questions from the committee? No questions?
Okay. Thank you, Mr. Chairman. I will turn then to the Judicial Council proper and the Administrative Office of the Courts request lines, which are all in your 6.4 section. The first is 6.4.1. This is the ongoing initiative we have with medical legal partnerships. We certainly appreciate the support that the legislature has provided in this space for us over the last several budgeting cycles. You will see a request for $209,500. We would not turn that down, but want to be candid and transparent that our process of ramping up the appropriation you made last year has been slower than anticipated. A sort of a collection of things like a maternity leave and various other factors. And so as we are digesting that role, we always want to be good stewards of the resources you allocate to us. We still recognize the real need in this space, but also don't want to get ahead of ourselves in terms of resources that we're not ready to deploy at the beginning of the fiscal year. So we certainly would not say no. We would work to make sure that that happens with our partners, but also recognize that we're behind on that project, and so don't want to create any unrealistic expectations there. But certainly are continue to be very pleased with the progress of our medical legal partnerships and excited about what's happening in that space. 6.4.2, this is an ongoing initiative driven primarily by the Access to Justice Committee and led by Justice Colvin. There used to be this concept of a law library in our communities, but we're not talking about books. These are really legal self-help centers where individuals who are unrepresented have access to various forms and those sorts of things. You appropriated funds for us for a study from the Carl Vincent Institute of Government that try and help find best practices and appropriate metrics for determining ROI. That report is still not finalized. It's not back from them. This is a continued request for us. We are not currently equipped to sort of target metric and say, well, if you give us this many more resources, we can show this ROI, or this many, if we direct them in any certain way. So we are continuing to be a little bit flying blind as far as how to be able to to give you validation for the investment. And so this is the same number that we've asked over the last this is the third budgeting cycle that we've asked for it, but it is to fund grants to support these legal self-help centers, all in rural areas or remote areas of the state. There are some really fantastic legal self-help centers in the metro area that are funded by county dollars.
Do you know how many we have in the state today?
We participate with the Middle Georgia Justice Program has one in Macon. The Appalachian Circuit has one up in Blue Ridge. The Doherty Circuit has one in Albany. There are other iterations, but not ones that the Access to Justice Committee have worked directly with. The one that's in Fulton County is not one that we have ever really engaged with from a sports standpoint, but it's really nice. Congratulations to Fulton County folks on a really fancy facility. It's really nice. Yeah.
Great, thank you.
Thank you. Turning then to 6.4.3. This is a rehash of a presentation you've heard before on judicial security initiatives, and there's a two-part here, one of which we believe we will withdraw, assuming favorable consideration of some legislation. This is the issue you'll remember last year about protecting personally identifiable information, where much appreciated the initiative of the legislature at our request would have actually probably created more information to protect. And so the legislation that you're considering this year, we think is a cleaner way of addressing that, which really, assuming favorable consideration, will evaporate the bulk of this request. It will leave $108,071 related to an opportunity we have for tracking threats against all Georgia judges, primarily in the online setting, in the digital world. And so that would be a position that we would certainly want to retain. So that line, our request for what it's worth, goes from down to $108,071, down from the $340,000 that you see there. Again, for the security opportunity. The next line is 6.4.4. This is just a straight request for increased funds for targeted recruitment and retention. This reflects a 5% fund for us to use. Obviously, to the extent there's any sort of statewide initiative, this would get cannibalized or absorbed into that from our standpoint. But that reflects a 5% pool for us to do recruitment and retention efforts. Our next line this is the JCATS annualizing the case management contract. The legislature has continued to focus its efforts on improvements in our juvenile courts area, including making sure that all of our counties have access to the JCATS system. We have seen 20 counties implement the JCATS, and we have more in queue, and hope to have more in queue. Nudge, nudge, wink, wink to all of our friends in that space. But we continue to want to make sure that we are capturing usable, relevant data for all stakeholders, including you and the legislature. So this is just the case management contract there. Then 6.4.6, these are the same three IT personnel that we were briefed on at your last committee hearing and that you funded, which we appreciate very much, in the amended budget. And so I will certainly respond to any questions about them, but don't want to force you to listen to that once more. Mr. Chairman, I'll obviously take any questions. You will note in that section the Judicial Qualifications Commission still falls under the Judicial Council for budgeting purposes. Courtney Veal is here, and as is our tradition, so I will yield to her at the appropriate time so that she can present to the JQC.
Right. Okay, thank you. Are there any questions related to 6.4 section? I do have one for me. So I know JCATS has been a topic of conversations. I've had a number of meetings around JCATS since I've been in this role. And I also heard you say nudge, nudge, wink, 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 wink. What can we do in the legislature to nudge, nudge, wink, wink on getting a better adoption of JCATs?
It's a great question, Mr. Chairman.
If you can't answer, you can say I can't answer. That's okay too. But I feel like there's some good opportunity here for people listening that maybe JCAT's adoption would be looked.
You're the policy directors in the state, Mr. Chairman, and I'll just observe that the legislative power of the General Assembly is plenary. So I'll let you
Fair enough. All right. Any questions? All right. Thank you so much.
Thank you very much. Thank you.
Next up, we'll have Georgia Statewide Business Court.
Good morning, Mr. Chairman.
Good morning. Thanks for being here.
Good to see you.
Used to be a senator out my way in Paulding County, so I appreciate you
Yes.
being here.
I remember us in some meetings out there,
That's right.
working the crowds. Good to see you, Mr. Leader. I'm Bill Hamrick. I'm the statewide business court judge, and we appreciate you allowing us to hopefully quickly present our request to you for FY26.
And for everyone, this is 6.7.
Section 6.7, thank you. 6.7.1 is recruitment and retention, and I'll stand on Justice Bethel's explanation of that. We deal with the same issues, and working with Andrew, who helps us with our budget. We are, by the way, we're assigned to the Judicial Council for administrative purposes, and so we contract with them to have services, and Andrew also puts our budget together. So that aligned very well with some of these issues. So we have a request there for $60,000, a little over $60,000. Also aligned with the request from the Supreme Court is 6.7.2, the compensation reform. That is our portion of that, and I know that there's still some work being done on the numbers, and we would just ask that ours be consistent and proportionate to what you decide to do with regard to the other statewide courts. And then the only other request doesn't involve any funds. It's 6.7.3, which you helped us with in the supplemental budget. We have some funds that come in from filing fees that I didn't really know what to do with. I couldn't find a statute that gave me the direction on how I could use those funds, and so they've just been sitting there. And so working with Andrew, we just decided to put it in the budget so that you can recognize them as part of our budget, and then hopefully we can utilize them for equipment if needed. So that's the purpose for that. And that's all we have.
Representative Holcomb?
Thank you, Mr. Chairman. How is your case flow? My understanding was when the court was started, it was pretty slow. Where are we today?
Of course, I anticipated that question because I know there was a lot of discussion about that when the court was getting started a little over 4 years ago. So if you compare our caseload to Superior and State Court, ours would be substantially lower. But after giving some thought to that's by design. So I looked for comparisons where we could get a good feel for what our caseload is and should be. And so when the business court was set up, it was based on North Carolina's business court that was mentioned in the Court Reform Council. So I've been looking at North Carolina's numbers, and in 2023 they had 37.8 cases per judge. They have more than one judge now. They've been in existence for 30 years. So I broke it down by judge, and we had 38. In 2024, they had 41.2 cases per judge, and again, we had 38. I believe the Metro Business Court is going to have less cases than we have because their judges also have their regular caseload. So, and the Fulton County Metro Business Court was also mentioned as a model for our business court. So as compared to other business courts, I believe we are about at the same level, and which would indicate that we've come a long way in a short amount of time on getting our business court set up, mainly thanks to you, the legislature.
Can I ask a follow-up? In terms of those numbers of the 38, are those largely the same cases that are navigating through the system slowly, or are they new filings?
They're new filings.
Okay.
Those are based on pending cases plus new cases coming in. Of course, we've resolved 75% of the cases that have come to us. We've had a total of 116 cases, and so we have resolved 87 of those cases. So they're new cases coming in, they're cases we're resolving, so it's always changing in terms of the cases we have. I've got some that are hanging around that I'm going to have to try, and we've got a 3-week trial coming up in Fulton County in a couple of weeks. I mean, some of them won't resolve on their own, and so I've got to set them for trial, and I've got a couple that are older cases that I'm doing that with, hoping we either get through the trial and get a verdict or they settle.
Okay. What's your current open docket?
We have about, and have had since I've been there, about 27 roughly open cases that are we're working on.
Okay. All right. Thank you.
Thank you. Leader of Administration.
Thank you, Mr. Chairman. Thank you, Judge, for your presentation. I suppose this is more of a comment I'm about to make and then would invite any response that you may have. But my recollection when the General Assembly debated creating this court, there was a lot of discussion around really narrowing the subject matter jurisdiction to ensure that there'd be greater opportunity for focus, expecting complex litigation to be brought in the court that's going to require more time, more focus, often complex circumstance around parties, things that I can't even fully appreciate, but just that would require a lot of time and focus. And it's just my assumption that work wouldn't necessarily be reflected in the case count number. If you just look at the number, you're not going to know the amount of time and specific issues that often have to go into the work around those cases.
That's absolutely right. And again, some of this I've had to learn as we go, but for the open cases we have, or let's say for the 38 cases, that's 198 lawyers, 250 claims, and 163 parties. And there's me, a staff attorney, and 2 term clerks that I get for a year that have to sort through all of those cases with that number of attorneys and claims and parties. And that's where the complexity is. It's in the numbers of filings that we deal with and the hearings. And we've had over 100 hearings. They file a lot of motions, and we have hearings on the motions. They have a lot of discovery disputes that we get on a conference, a Zoom conference with the attorneys, and work out those and get them a decision on the spot. So there's always, with that number of attorneys, there's always something that comes up on the cases that we're working on. Thank you for that.
All right. Any other questions? Thank you so much. Appreciate you being here.
Thank you.
And next up, we'll have the JQC. And that'll be 6-5 on the tracking sheet.
Good morning, Chairman, and members of this subcommittee, including my former trial partner who I see exiting my stage left. Anyway, we appreciate the opportunity. We appreciate the opportunity to be here this morning, and I've had an opportunity, I know, to talk to you, Chairman, about the functioning of the agency and the way in which the agency has changed since it was reconstituted in 2017. I'm in my second year as the director of the agency, and we continue to see change and exponential growth. And so just to give you all an idea, when I started at the agency, the first year I was here, 2020, we had about 430 complaints come in. In 2023, we saw 1,100 complaints come in, and last year in 2024, we saw 1,700 complaints come in, and that is not because judicial misconduct has suddenly increased overnight. I think there are a lot of factors that contribute to that increase. We're seeing a lot of our proceedings live streamed, and again, we're living in a time when the public's attention on the system, including the judiciary, is heightened. And so I think a lot of the public and our bar in this state is much more aware of the commission and the work that we're doing. One of the most drastic changes to the commission, I believe from the prior version of the commission to now, is that we are actually litigating our matters. And so when the commission was reconstituted in 2017, you all rightfully bifurcated our panels. There is now a panel that oversees the investigations and prosecutions, and so they oversee me and the investigations that I conduct, and then I lead all of our prosecutions. We prosecute our cases in front of our hearing panel, and so I have with me Judge Brian Rickman of the Court of Appeals. He is now, as of July, the presiding officer over our hearing panel. Our hearing panel has 3 members. They are all volunteers, unpaid. They all have otherwise full-time jobs, and so they volunteer their time to come and hear the cases we prosecute. Again, because we are actually litigating our cases now, it requires our 3 hearing panel members to take time away from their full-time jobs to come and sit and hear our cases. And so the last 2 cases that we prosecuted before our hearing panel each took about 2 weeks to complete, with the presentation of evidence and closing arguments. And that does not account for all of the pretrial litigation and then the litigation that occurred toward the end of the trial. It requires extensive research, motions practice. The judges that we are prosecuting hire, and they should, very good trial lawyers. And so again, we're seeing a drastic increase in our litigation. So I want to start at, and I'm in section 6 and I'm at 6.5. I'd like to start with 6.5.3, and that is our request for an increase in funds to fund 1 staff attorney position for the hearing panel. You'll see that we are going to utilize existing funds. So we previously made a request, it was under the prior director, for funds to be used for our hearing panel, and we have utilized those funds for hearing cost, court reporters, any kind of costs associated with our litigation. So we're going to pull $50,000 in those funds, and the ask is $117,614. We'd hope to pay that person around a salary of around $100,000 a year, and so this also includes benefits. The $100,000 per year, after I consulted with Judge Rickman, the hearing panel staff attorney position, what they'd like to see is somebody with 5-6 years of experience in that position, given the kind of issues that are required or are coming up, the research required, the writing that is required. Ultimately, everything that flows from the hearing panel goes to our Supreme Court. And we want to do our best. I know they want to do their best to get things right. And so something that I think is important to note is that the hearing panel functions as if they are my trial judge. And so our rules provide that my staff that I have on the investigative panel level cannot assist the hearing panel in any way, which makes sense because we're investigating and prosecuting. And so right now they don't have any staff. They've relied on volunteer lawyers to assist them during our trials. And what that has looked like is somebody volunteering and sitting through our 2-week trials and then helping them on the front and the back end with research and writing. We expect this position, we expect that the amount of work that the hearing panel has, which includes litigation and hearings, but also includes a review and revision of our formal advisory opinions. We expect that a full-time position would be justified for at least the next 2 years, based on the volume of litigation we have right now. We have 3 matters pending that need to be litigated before the hearing panel. We're actually set for a hearing within the next few weeks before them. The formal advisory opinions are important because those are our formal ethics opinions that have been published on the Supreme Court's website. They're out there for the public and for judges to utilize if they have questions about recusal, fundraising, any of those issues. They can review our formal advisory opinions. Those they need to be reviewed by our hearing panel, and the hearing panel has to conduct the review, and then they have to go to the Supreme Court. And so it would be wonderful if they had somebody with them full-time dedicated to reviewing those opinions, many of which are based on the prior version of the Code of Judicial Conduct. And so we need to get them updated for our judges. So that is our request at 6.5.3, and then I'll move to the more simple request. 6.5.1, I have made a request to increase our funds based on the increased rental rates through GBA. So last year, based on security issues we were having at our office space, I had to relocate the agency downtown. We're now at 244 Washington Street, but by the time we got down here, I missed my opportunity to ask for an increase based on the increase in those rental funds, and so that's that request. It's $13,764, and then at 6.5.2, I've made a request to increase funds for outside legal fees for unanticipated defensive litigation costs. As we're seeing, and I know I'm not alone here, people like to sue, and that's fine. People have the right to do that, but last year, the JQC was sued twice in federal court. On each occasion, and I'm not knocking the AG's office, but on each occasion, the AG's office declined to represent us, and it left me in a position to have to search for somebody to represent us. And luckily, on the first occasion, the governor's office was willing to help us out, but that representation totaled $94,000, and again, completely unanticipated. That matter ended up getting dismissed in the JQC's favor, and so we prevailed on that matter, and then sued again in federal court where somebody is alleging we violated their First Amendment rights. Motions to dismiss are pending in that matter, but the AG's office declined to represent us there, and so I had to spend my time finding an attorney for us, and I'm currently paying an attorney to represent us there. The last I calculated, we were at $27,000 that I have paid out to that law firm, and we are just in the early stages at motions to dismiss. I hope we prevail at that stage, but if we do not, I will have to continue to fund the cost of our defense in that circumstance. So that completes my requests, and I'm glad to answer any questions.
Thank you. Yeah, you do have a question. Representative Evans?
Thank you, Mr. Chairman. Thank you for your presentation. I have 2 questions, if that's okay, 2 different subject matters. The first is, you talked about the complaints coming to the JQC being, 440, going to 1,100, going to 1,700. Are you able to ballpark with a percentage how many of those you're able to, if any, sort of, okay, you have a right to make a complaint, but this is frivolous and you can move it quickly, as opposed to the ones that you have to really have someone dig into?
Yes. So we, every year, and we're in the process of doing our numbers for 2024, but every year since I've been here, we dismiss after just initial review or after just an initial investigation between 80 and 85%. And so obviously when our complaint numbers were lower, it was much more tenable, but now we're looking at doing an initial investigation or a preliminary investigation in a lot more matters than we used to do.
Okay, thank you. And then the second question is, in the 2 cases that were filed against the JQC where the AG declined to represent, what was the stated reason for that?
So I understand that the AG is an executive branch agency. We are a judicial branch commission. And in the second circumstance, the one that is still pending, there were multiple co-defendants in that suit that are judges. And the AG was representing the judges, the co-defendants. And so I believe part of it was we're representing the judge co-defendants. We don't want to also represent the JQC, who oftentimes does have adverse interest to the judges named in the suits. Although in that suit, there were not adverse interests.
And what about the first one?
I understood the rationale to be that they are an executive branch entity and we are a judicial branch entity, and so representation was not required.
But the AG has represented judges, it sounds like.
Correct.
Okay, thank you.
All right. Any other questions? Yep, 15. Representative Holcomb.
Thank you, Mr. Chairman. I'm looking on your website now, and for the recent actions, the last one there is from 2021. So is that really updated?
It is not.
Okay.
And back in 2021, under the prior director, we consulted with the Supreme Court, who obviously promulgates our rules. And it was decided at that time that all of our recent actions would be published via their website, the Supreme Court's website, where they maintain a JQC docket, because we do not have a clerk. The Supreme Court's clerk is our clerk. And so all of our recent actions, including filings, decisions, are housed on the Supreme Court's website under judicial disciplinary matters.
Okay. And with respect to the two basic criteria that you all investigate are misconduct or potential incompetence of more senior judges that may need to step down. For those for which there are credible complaints, are there common factors and denominators, and are there any interventions that can be done in terms of training or otherwise to try to keep people from winding up in this position? Like, for example, social media posts that are inappropriate or other things like that, which seem like it could be corrected by some good training.
Absolutely. So social media was an issue that we saw. We saw an increased number of complaints starting to come in based on social media conduct in 22 and 23. And so part of what the JQC does as well, which I feel like not many people know about, is we are required to, and I do, instruct the judiciary on judicial ethics. And so what that looks like is all of the judicial conferences around the state for every class of court. Generally, we, either myself or my deputy director, go and do the judicial ethics component piece for all of the judges. So when I started, the prior director, Director Boring, I know he did a handful of presentations. I concluded last year, between myself and my deputy, we did about 23 ethics presentations over the last year. And so we have focused on issues related to social media, and we actually saw the number of complaints coming in on social media issues decline over the last year. Another issue we see, and it's always the top of our list, temperament-related issues. We get a lot of complaints in that area. And then patterns of failure to follow the law. That's something we also see. So again, we tailor our ethics instruction to the issues that we are most frequently seeing with every class of court. My hope is that one day we'll really see our complaint numbers and the ones that we're investigating and that are resulting in discipline decline, especially in those areas where we are directing our instruction.
Okay, thank you. And one last question, if I may, Mr. Chairman. In terms of the cases that are litigated, can you describe for us your success rate? I'm imagining that it's fairly high in terms of it's got to be fairly significant misconduct to merit taking it to trial. And is that a fair assumption on my part?
It is. In our last two cases that we prosecuted, we sought removal, and the Supreme Court did remove each of those judges. Former Judge Coomer, that was removed in 2023, was the first judge that had been removed by order of the Supreme Court in over 12 years.
Okay, thank you.
Thank you. Any other questions from the committee? Well, thank you for your work. I'm sorry. I know we did talk a good bit about security in the office and things that going on just out in society. And so appreciate everything you're doing. And I think that's it.
Thank you.
Mm-hmm. And next up will be Court of Appeals.
Yeah, we don't accept.
Good morning.
Morning.
I am Trent Brown, judge with the Court of Appeals, and I'll tell you up front, my chief judge, Mercier, she anticipated being here. She texted me at 4 o'clock this morning that she would be unable to be here due to sickness. And then typically, our budget chair, presiding Judge Doyle, would be here. So I am actually the C team, but I'm happy to be here.
We're glad you're here.
I appreciate y'all here.
You're never C team here. You're A team here.
We'll see.
That's
We'll
right.
see. It's still early.
Well, I'll reserve my comment till the end, and I'll let you know.
All right, starting with Court of Appeals, on our request 511, we're asking for an increase in funds to the annual cybersecurity insurance premiums. I think that speaks for itself. 512, increase funds for annual leave payouts. There's been some discussion, I think, that we actually were given that in the amended budget as well, so it would be carried over from that. It's the same number, the $80,000. They are payouts for up to 45 days whenever we have retiring employees. 513 is an increase in funds, Phase 1 for recruitment and retention for our attorneys as well as our professional staff. That's, I believe that's on average of about 5% across the board. That also carries over to 514, where an increase of funds for the balance of our court staff as well. And as has been talked about with both the business court as well as the Supreme Court, 515 represents the money necessary for the increase in judicial salaries per the pending bills in both now in the House. I will say, as Justice Bethel mentioned, there will be some adjustments there. We believe theirs will probably just slightly up, ours slightly down. Ultimately, there'll be a net gain when those numbers are balanced out.
Okay.
Ours will be reduced by about $300,000 once the numbers shore up if the bill passes as it is today.
Okay.
And I'll entertain any questions to the best of my ability.
Yeah, so same question that I had for Justice Bethel. If we step into this pay raise instead of, is there an avenue that's best? Is it best to hold it and go at one starting date later? Is it best to, give it and walk it up later as we go?
Just to qualify the question, do you mean for the staff or do you mean the judiciary
for
or do you
you,
mean across
yeah.
the board?
No, for judiciary.
Of course, we want as much as possible, as quickly as possible. We certainly appreciate your consideration in this matter. I think it's, with inflation, as we've discussed before, I think there's been substantial change to where in the purchasing power of people in similar circumstances. So we would ask to do it as quickly as possible, but certainly, again, we appreciate any consideration you're willing to give us.
I guess what I'm saying is outside of as quickly as possible. If we did half of it this year, stepped
Right.
into it, say we did a 2-year process.
Yes.
Is there certain boundaries that would be beneficial or not beneficial?
But
for doing
ultimately to the same goal? Now, are you talking about, would the initial be in January or would it fund July 1?
No, January's done. It'd be July 1.
Okay.
So, is it what is best? Is there an avenue that's best to say July 1, take as much as possible? So you get that, you get the year, half of it, or in December, you get the full of it. Like, does that make sense what I'm saying?
It absolutely does.
Same amount of money for us, it's a little bit different from you, so.
I would say, considering outside circumstances, getting the amount, the highest amount possible early would probably be the most beneficial, and then we could come to you later to ask for it, because there's always circumstances that could change between now and then where nobody gets anything at a later date. So I would imagine the typical bird in the hand argument.
Okay. Number 16, Representative Evans.
Similar question that I had for Justice Bethel. The turnover are your numbers about what the
Ours
Supreme
are
Court is
slightly
seeing?
less. They're around 64% on average. Is that right? So we are slightly less, and I think our average, we have people who have been with us longer, many of which who have maxed out in their salary. So I think our average is a little bit higher. I think they quoted you around 123. We're about 125 on average among staff attorneys.
Okay, thank you.
And following up, I think that we're at a point in the court, I believe both courts, where we're in real danger of losing core knowledge among the staff attorneys. We've got several folks, I've got one in my office who maxed out quite some time ago, with the exception of COLAs or otherwise, have really had no raise. And not only are we competing with the private sector, there are circumstances where we actually compete with the public sector, where there's offices that pay more than we do. So there's a real need in, hopefully, the first step of many in increasing, simply to compete with inflation among our staff.
Thank you, Mr. Chairman. I wanted to ask a few additional clarifying questions.
Sure.
For 5.1.3, if that's a 5% across the board increase, how much of that kind of disparity does that decrease in terms of public versus private market?
Go ahead. I'll probably follow.
Sorry, I may not do this justice either,
And
Representative.
this is Chris Walker,
but-
our CFO.
Good morning. Good to be here and good to speak to you, Representative. I would say that as far as public versus private sector, or us versus, I'm not sure about those numbers. I know there's been some exorbitant salaries that you're looking at that people are leaving for. But what I can tell you is over the last 10 years, everyone's lost 30 cents on their dollar, period. And so that would be 5% of that 30%. That might be the most relevant information.
A few additional follow-ups, if I may. So where do our Court of Appeal judges, in terms of their salary, what does that look like regionally compared to our neighboring states?
I want to say, I've had several judges that said that came on before me that we were within the top 10 to 15 in the 50 states, and right now we're around, I believe the Supreme Court's at 40th, and we're around 30th across the nation.
And then my last question, because I think I missed this part on the Supreme Court aspect, the phase one, can you speak a little more to the phases? What is kind of the anticipated plan for these increases to decrease the disparities between public and private sector?
Sure. And with the judges themselves, the bill calls for it to be attached to what the Northern District judges are making. So their increases are per year based on an index that's attached to inflation. So that's where those increases would come from. Really what we're looking at with the staff that we've discussed in hopes of a 3 to 7% raise over the next 3 to 5 years, we would hope that would eventually get to a point to where we're pretty close to competing with what inflation has taken away in purchasing power over the last several years.
Thank you.
I hope that answered your question.
Yes, sir.
All right. Any other questions from the committee? Thanks for being here.
Thank you, Mr. Chairman.
We give you a B.
All right, I'll take it.
Next up, we have Superior Court.
Good morning, Mr. Chairman.
Good morning. Thanks for being here.
Thank you so much for having us. I am Judge Ann Harris. I'm president of the Council of Superior Court Judges. I'm a Superior Court judge in Cobb County. With me is Mr. Charles Miller, who is the budget director of the Council of Superior Court Judges, and certainly my right-hand man when it comes to these discussions. I have y'all's tracking sheets, so I'll just kind of go with that. A lot of the requests that we have here are things that probably a number of y'all are used to seeing. The first one, 9.3.1, it's $808,000 to increase the funds for the employer contribution for JRS from 6.43 to 8.89. This was approved by the Retirement System Board, and it just kind of is what it is. Items 9.3.2 and 9.3.3, those are to annualize funding for new judgeships that were approved last year in the Houston Circuit, which is, of course, Houston, Perry, and the Tifton Circuit, which is down south, has about 5 counties in it. Those new judgeships were created in the 2024 legislative session, but the funding was pushed to January 1, 2025, so this is just to annualize those numbers and add the remaining 50% of the budget, 50% of the funding to the 2026 budget. The next 3 items, 9.3.4, .5, and .6, are to create an additional judgeship in 3 circuits, and I think a lot of y'all are familiar with it. That's based on workload studies that are done every year to measure, and it's an objective measure across the state to try to measure circuits that are in need of an additional judge. And so these 3 are the ones who have those highest workload values: Alapaha, Augusta, and Douglas. And so that is to request a full year of funding for those additional judgeships. Right now we have an effective date of July 1 of 2025, and so that's the request for funding for those 3 judgeships.
Hang on, we got one quick question.
Yes, sir.
14, Judge Gunner.
Thank you, Mr. Chairman. The effective date was what I was concerned about, because we had the Alapaha Circuit bill in committee, and I was told it was to start at July 1st. We did that, sent it out to rules, and it came back because the budget's going to be January 1.
January 1.
Uh-huh.
Yeah. And that's so.
But they change the dates and then they'll adjust the funding.
Yeah, I think the funding will get adjusted. In fact, I think that happened last year. The funding got adjusted when the effective date got pushed back. This was just the request for the funding. So I guess.
Yeah, we're going to do most judges starting January. So it's just, it never starts off in July. Whenever it starts in July. So give a little time for the appointment.
Yes, sir.
And everything else.
And I think y'all have done that the last few years.
Right.
Yes.
Okay, go ahead. Sorry.
I'm sorry, was there another question? Okay. So, we'll move on to 9.3.7. This is a request for funding to implement judicial compensation reform, 19.29 million. I don't want to plow old ground, but I do want to kind of highlight some of the features of the compensation reform bill. There's enabling legislation that's traveling for superior courts under HB 85 to create a statewide base salary for superior court judges. It is related to the U.S. District Court judges, who are the federal trial judges. And what it does is provides for what's called a maximum authorized salary. That's 90% of the district court salary as of 2 years earlier. We felt like a 2-year look back was appropriate to just avoid any kind of surprises. But of course, that's still a maximum authorized salary. That's not a requirement. And by tying it to the federal district court salary, it allows for incremental increases through the appropriations process rather than through statutory changes. Now, the amount that we are requesting is actually about the same amount that was asked for last year. I think it does reflect the 3% cost of living that we got from the governor last year that was provided for a number of public servants. But it's essentially the same number as last year, so it's kind of converted into a 3-year look back, but we just we thought the prudent thing to do was to stick with the request that we had made last year. Now, the big key to the enabling legislation that kind of makes this work and gets rid of this huge disparity in Superior Court judges' salaries is it eliminates the practice of county supplements. That's how the salaries got so uneven across the state among Superior Court judges. And it's how we ended up as Superior Court judges with a base salary that is, for the 8th most populous state, 49th in the nation, saved only by West Virginia, which is inexplicable, but that base has remained low because so many counties added these supplements in there. But then you end up with a range of supplements that's anywhere from, $10,000 or $12,000 to $70,000 or $80,000, which is just is a huge disparity. And for judges that are elected statewide and do the same work, that just was something that has needed fixing for years. So so county supplements are eliminated, but what was put in place was something we've titled locality pay. But that's very limited. That's capped at 10% of the state-based salary, because the notion is you need to recognize true cost of living differences between urban and areas, kind of some of the metropolitan areas. And I don't just mean Atlanta. I mean Savannah. I mean, Macon, Columbus, some of those more populous areas where there is truly a higher cost of living. But that locality pay is capped at 10% of the base. One thing we did this year, and just so y'all know a little bit of the backstory, this is the second year of this effort. We spent a lot of time working with a lot of stakeholders involved in this, ACCG, some of you all in the House, as well as some of your counterparts in the Senate, to try to address concerns last year. And one of the things that we have in here is a reduction in that locality pay. Or I guess I should say, if the base salary continues to rise incrementally, that locality pay will drop. And at some point, the locality pay does, in fact, disappear. It goes to zero. So it never exceeds 10%, but if the base increases, the locality decreases. And there's a specific formula for that. I can give it to you if anybody's really curious. A couple of takeaways that I think are helpful when you're thinking about the appropriation. We recognize that $19.3 million is a huge ask. And yes, the judiciary's portion of the state budget is only like 0.6%, but $19.3 million is a big number. But what I would ask that y'all remember is this is spread over almost 230 judges, and it doesn't represent an enormous raise in the total compensation to a given judge. For example, for me and a lot of my colleagues, it's not a raise at all. For many of us, it's little or no increase in our total compensation because we're getting rid of those county supplements, and it just, as your colleague Rob Leverett said, it shifts the responsibility to the state for paying state employees who's right now, so many of them are being compensated so heavily by the counties. The other thing I wanted to emphasize, and thank y'all for giving me a few minutes, is the pay disparity that exists among circuits is real, and you can see that in the numbers. But to the question, I know that I can already tell from the questions, Mr. Chairman, that you've asked the others, the question is, well, what about partial funding? So what I would ask you all to think about is if HB 85 is not fully funded, and we can talk about when that funding happens, if it's not fully funded, what we're doing is we're now creating a second level of disparity, but we're creating it not between a metropolitan area and a rural area. We're creating it between a judge and a new judge one door down in the same circuit. Because, judges who are at their current level, they're not going to suffer a loss in their salary. They're permitted to keep their existing salary. But if this were to be partially funded, at $30,000, for example, and the math is really rough, but for example, in my circuit, I'm making about $221 right now. A person who comes on board next year would make about $180. And that's the person right next door to me in the same circuit, doing the same work, serving on the same committees, doing the extra work for rules and things like that. And that's a brand new disparity that we've created that is difficult. That's difficult. So, and the reason that's why is because, we've got the legislation that says new judges coming on board, they need to go into the new system, which we all agree the new system gets rid of the disparity. But what we don't want to do is create another disparity that just replaces the old one. So those are my remarks on that. But certainly if you want to talk about specific, funding steps, I'm happy to do that as well.
Okay. I'll come back to that one. Go ahead and you can
Okay.
finish out.
Well, honestly, on 9.3.7, that was about all I had to say. So I'll move on to 9.3.8. I think, as you know, the Douglas County judgeship that was submitted last year ultimately did not get created, but the funding was there, and there was a substitute bill and all kinds of maneuvering, but ultimately the funding was increased, but it wasn't needed because the Douglas Circuit new judgeship was not created last year. So there was a request to already remove part of it out of the amended budget, and now this is a request to take it out of the 2026 budget. So that's 9.3.8. And then 9.3.9, 10, and 11, those kind of go together as well. That is for the Atlantic Circuit and the Coweta Circuit and the Doherty Circuit. That is essentially backing out the one-time setup expenses you have associated with a new judgeship, equipment and subscriptions and furniture and stuff like that. So it's to back that out. Those were judgeships that were approved last year. And that's my presentation, ladies and gentlemen.
Really appreciate that. I'm going to go back to the pay raise, appropriations piece
Yes,
of
sir.
it. So there is a disparity, but it's going to be disparity no matter what, right? I mean, for instance, there are some judges who are going to be carrying over, say, $225,000. And a new judge in that circuit is going to start out at whatever the new salary is. I don't know what it is, 170. I don't know what it is. So we're never going to get rid of disparity for doing the same work.
Well,
so for instance, will the new judge make as much as you today? You're a little bit, because you're kind of equal, right? I mean, this is basically, Cobb is a little unique, I think, in as far as it's really an equal transfer for the most part, or close to it.
it would be pretty close to it. For example, in Cobb, with the full funding at 90% of 3 years ago of the federal district salary, but that assumes that the county adds the 10% locality pay. It's pretty close, and other circuits. Other circuits that don't have as big a supplements, those judges will opt in because they will opt in at the 90% mark, if you will, because that is advantageous to them. And so they will opt in, and so they will be if they opt in at 201, they will be about where we are as well. So, for example, and this may not be answering your question, but certainly a judge near the very, very bottom whose circuit only pays a 10% supplement at this time, for that judge, it would represent a very substantial raise.
Right.
But there's not that many of those judges.
I'm thinking about the people at the top, though. So I'm not sure where the top is. Columbia, I know, is up there. Probably
Yes, sir.
Fulton is up there.
Mhm.
So there's still going to be disparity in those for the old judges and new judges. We're not getting rid of disparity. You're just saying, hey, this maybe makes it a little bit worse for a little while.
It gets it really close. You're not totally getting rid of the disparity, but you're getting real close to getting rid of it.
What's real close in your mind? Just out of, you can guess it. $20,000.
Ooh.
$10,000. 1,000. Make a deal.
I would think, I hate to play around with numbers, and that's why I'm a lawyer. I can't do math. I would think if you're talking about a few $1,000s, but it's designed, the number, that 90% number of the federal district pay, that was a finely threaded needle to try to get everybody to about the same level. There are some judges that would probably not opt in, but when those judges retire, that's it. The person that replaces them is going to come in at the new number. I'm not sure I answered your question.
Yeah. I'm good. Number 16.
Thank you,
Yes,
Mr.
ma'am.
Chairman. Thank you, Judge, for being here. I had a question. We were talking earlier with the business court about their caseloads and how those cases are complex, which I don't dispute that they are.
Mhm.
But I wondered, and if you need to get back to me, that's fine. But my sense is that a Superior Court judge, particularly in a metro county like Cobb or Fulton or DeKalb, is going to have at least 30 pretty complex civil cases at any given time that have multiple party plaintiffs, multiple party defendants, discovery disputes, on top of a criminal caseload and domestic and everything. And I just wanted to see if I was correct in an assumption like that.
We certainly have some. I could probably get back to you with, I guess I could look at our workload stats. Because the way we weight the cases, there are certain categories of cases where you're going to tend to have a lot more litigants than other types of cases. And I could look into that and try to get back to you, but I think it's fair to say every judge is going to have a handful of those. It's hard to say how many, but
Sure.
I could think of probably off the top of my head 15 or 20 that I have. Yes, so every judge is going to have some of those.
And any ballpark figure of the caseload, let's just take you, for example, pending cases right now.
Okay, my guess is, and this would be, because I haven't looked at it yet, because the
Yeah.
workload stats aren't in, I probably, well, let's see. My guess would be 200 to 275 criminal, more than that on the domestic front. Civil is a little hard to tell because, to your point, some of them have a huge number of litigants, and so it's kind of hard to say that's just one case. Probably not as many civil, certainly as domestic. Normally, when we think of our caseload, we think of it as about 40 to 45 criminal, 40 to 45 domestic, and the remainder is civil, but the civil sucks a decent amount of oxygen out of the courtroom because those can be complex.
And you can get back to us on the numbers too. I mean,
Sure.
you gotta,
Yeah.
if you don't have it, that's fine.
Okay.
And that gives me what I need.
And it also depends on different times of the year. I mean, right now, things are really under control in one area in my courtroom, but, 6 months from now, it's kind of driven by the progress that the DA's office is making with their criminal cases on the criminal side, for example. So, yes, sir. Any other
Thank you.
questions?
You want to have anything? Well, I appreciate you being here, and I appreciate
Thank you
what
so
you do for the
much.
Cobb citizens and for Georgia. Thank you so much. Okay, we got PAC is next. Appreciate y'all being here.
Thank you, Mr. Chairman.
Gotcha. All right, for those following along, this is page 5, section 8.
Mr. Chairman, with your permission, DA Cranford is going to start with the DA program first, and then we'll go to the conflict program and the PAC program.
Yeah, that's fine.
Thank you, Mr. Chairman. I'm Herb Cranford, DA in the Coweta Circuit, also the DA Association Budget Chair. I do want to mention there are a few DAs in the back gallery back here, just in large part here to support our request to help out our people in our offices. And if you would, that's where I want to start, which is 8.3.3. I will say quickly, 8.3.1, we're just trying to annualize ADAs added for the Tifton and Judicial, Tifton and Houston Judicial Circuit judges, which has been referenced already today. 8.3.2, which I'll come back to, is just one step increase for our staff, the non-lawyers, victim advocates, investigators, legal assistants, similar to other presentations you've heard, trying to keep up with inflation and those kind of things for non-lawyer staff. But I think you've got a copy of our PowerPoint here. I think all of you do. Going to the third page of that, titled DA Budget Request and Competitive Pay, that's really what I'm wanting to emphasize to you all here. We are just not competitive in what we're paying our state-paid assistant DAs. A goal we've had and a way we've kind of thought about this is it would be really helpful when I'm recruiting somebody out of law school if I can say, if you stick with me for 10 years, you'll be able to make over $100,000. And right now, as you can see, Class 3, Step 3 would be making $91,734 if they're an assistant DA for 10 years. With the request we're making of you, that would get that 10-year employee right over $100,000. And that might seem arbitrary, but that's a number that's meaningful, I think, to people with law school loans and things like that.
And just so class, like for instance, when you start off your class 1, step 1, right?
That's right.
And go through 3 steps each class. Is that what it is?
I think it's 4, and then
4
you
steps.
jump to the next class.
Okay.
I believe that's right.
All right.
And the next slide is just emphasizing that the DA program budget is 98% salaries and benefits. So what we're talking about today is all going to employees and their salaries. The next slide.
Hang on one
titled-
second.
Yeah, go ahead.
You do have a question related to this. I'm going to go ahead.
Okay.
Representative Kelly.
Thank you, Mr. Chairman. D.A. Cranford, thank you for being here with us. Appreciate the job you do, as well as the 2 of my local DAs I see back there. I understand in aspects of all public service that there's going to be disparity with the position. You know, you're not. You have to compete with the big law firms, but you know, people that do y'all's job have a desire to serve the public. So tell me what kind of disparities may exist between the public sector, maybe in terms of what you're dealing with now compared with ADAs versus compared to public defenders.
Thank you for that question. Unfortunately, I think state-paid ADAs are the lowest among the government-funded lawyers in the state of Georgia. So we're starting behind prosecutors in the Attorney General's office. And as I understand it, over the last couple of years, the Public Defender Standards Council has indicated they're starting public defenders at $72,000. And so if you look at the next couple slides that start with 3-year pay scale implementation, it kind of gets to the question you're asking. We're proposing a 3-year plan, and in year 1, FY 2026. I'm on the slide that's titled 3-year pay scale implementation. What we're asking for this year would get us starting ADAs at 72,000 to match our understanding of what public defenders are doing. I don't think that catches us up to where prosecutors in the Attorney General's office are, to be honest with you. And to your point, I mean, I think when Mr. Skandalakis hired me out of law school and when all these DAs started working in prosecutors' offices, I think we all understand we're going to be making less than we could get in the private sector, and we sign up for that. You know, as public service, we're passionate about it. You know, I know some of these DAs, you know, haven't pursued judgeships and things they might have been able to get. So I think we all know we're going to be making less than we could, and that's why our focus is on not making what I could make at a private firm or an ADA might make, but just being competitive, and competitive with particularly other government funded lawyers.
I like to think it was keeping the scales of justice balanced.
Good analogy, yeah. So on that same slide, just to highlight, we're currently starting ADAs at 60,580. Like I said, with this budget proposal would start ADAs at 72,000. Right now, the top of the ADA pay scale is 125,481. So with this budget proposal, we would be adding 3 steps to the top of Class 4, which would raise the maximum salary for an assistant DA to 139,500. And there's a few slides we'll get to in a minute, but just to go ahead and mention it, 88 assistant DAs, which is 20% of the assistant DAs in the state, are capped out at the pay scale. And as you might imagine, God forbid anybody's child is a victim of a crime or loved one is murdered or something, but it's on those most serious cases, those are the ADAs that you want handling those cases, the ADAs that have been here for 15, 20 years that are maxed out on the scale because they have the experience, to get justice in that case. And so I think, in my view, and I think other DAs' views, it's really important to increase the top of that scale to keep those ADAs in our offices versus them getting pulled to the private sector. And I do want to just point out quickly, what we're proposing for elected DA pay is essentially just to keep the elected DA 10% higher than the top of the ADA pay scale that we're proposing. So if a topped out ADA is at 139,500, we're proposing elected DA pay in step 1 be 155,000.
You have a question?
Yep.
What part?
Mr. Chairman, are there county supplements to ADA pay?
Yes, some counties give supplements. There are a few counties I'm aware of that give the DA no county funding, and so the only funding they have is from the state of Georgia. But a number of counties, my circuit gets county money to supplement ADAs.
Similar to the prior conversation we had with the Superior Court judges, I'm curious as to the disparity in pay coupled with, the county supplements, and whether or not this would exacerbate, just kind of where ADAs may end up going to practice, for example. Could you speak a little bit more to how this step increase would potentially address some of the disparities that exist given the county supplements that are present in some of these jurisdictions?
Yeah, I appreciate that question. Using my circuit as an example, and I'm Coweta County, Meriwether County, and Troup. We split the circuit, which I'll talk about in a minute, but I used to have Carroll and Heard as well. So we're kind of a combination of metro Atlanta, but also rural. So I have an interesting kind of experience in that way. But my highest paid ADAs are the state funded ADAs. And I still have to use county funds to supplement some of those in order to be competitive with bigger offices. And my understanding in a lot of those big offices, the state funded positions are among the lower paid assistant DAs because the county funded positions are so much higher. So I think, raising state-funded ADA pay in my circuit would help me, get closer to competitive with other DA's offices that aren't as reliant as I am on state ADA pay. there are circuits, I've talked to DAs that don't get as much county funding to help out as I do, and obviously it would help them more. I've said it before, but this budget proposal, I think objectively would disproportionately help rural DAs, because those are the DAs most dependent on state pay.
Thank you.
I do have a quick question related to the supplement too. So when a county does supplement, sometimes that is in actual county positions, right? And sometimes you might have to use that, like you said, to supplement. But each county, that goes directly to the people there. It's not equalized. Basically, hey, so say the county gave you 5 positions or whatever, or matched your positions. I'm not sure how many ADAs you have. 4, 8. I don't know what you have. 4 maybe. Say the county provides you 4 ADAs to match it. Do you have to sometimes? How do you make that work? Do you hire 4 ADAs, or do you sometimes you can't hire one, so you might have to raise the pay of some other positions? Like, how does that work for you?
So I'm in the process of transitioning that. So, and this is consistent with how different offices do it. Historically, my counties give me funding, and I use it as best possible to pay people competitively. So they might give me, $100,000, and I use a bulk of that to create a new position to hire somebody, and then I use a small portion of it to give a state-paid person a little bit of supplement, right, to try to be competitive. Like the county position may be somebody fresh out of law school. Like I said, I put my more experienced people in the state positions. I'm transitioning, though, to try to save money on employer costs, to hiring people as county-funded positions, right? So I would hire somebody as a Coweta County employee, and the county would work with me to decide, what that person's getting paid.
Gotcha.
Yeah.
Okay. And then there's a disparity amongst, for instance, maybe in Paulding County we're the same, I believe. I think our state ADAs are paid more than our county ADAs, but maybe someone like Fulton County ADAs would be paid more than the state ADAs. So their best and bright, best folks would probably be county folks, and then this, Do you agree with that?
Chairman. Yeah, that's the point I was getting at a moment ago, that in my office and other DAs I know in more rural areas, my most experienced people are in those state positions because that's how I'm paying them the highest. It's the less experienced people I've got in the county positions.
Right.
But I think urban DAs are sometimes the opposite of that.
Okay.
Yeah.
Continue on.
Thank you, Mr. Chairman. So just going to the next slide is titled State Paid ADA Vacancies. The next few slides are kind of just anticipating some of the questions we get in these discussions, but there are 431 state paid ADA positions in Georgia. As of the end of 2024, we were right under 10% vacancies with 40 vacant positions. My recollection, having participated in these meetings the last few years, we've hovered right around 10% vacancies, 40 or more for a few years. And, if you look on this list, that list changes from time to time, but it's typically offices that are not, inside 285, for example. This next slide is just showing you what starting pay has been for assistant DAs since 2016. And when I was hired in 2012, it was like that 44,000 number from what I recall. Pay scale by experience currently is the next slide. Again, just anticipating some questions you may have, but that 10 years of experience is right at 91,000, as we pointed out earlier. And then this is the slide I referenced. 88 ADAs currently are maxed out on our current scale. That's 20% of all the state paid ADAs in Georgia. So I just want to emphasize, in my view, it's very important to add some steps to the top of the scale in this budget, because in my office, the most experienced people that I'm giving the murders, the aggravated child molestations, the rapes, it's those people at the top of the scale, and I naturally really want to keep them rather than, if they're in their early 50s or something, and they're getting attracted to a local defense attorney firm, being able to say, hey, we're getting you a raise this year would really help. ADA turnover, we've talked about this in years past, right at 20% this year. It seems to be kind of hovering around 20%. 2021 is an outlier. That was an election year. But substantial turnover. Just using my office as an example, when I presented to the Coweta County Commission last year, from 2020 to 2024, I'd lost 25 assistant DAs, and I only had 23 in the whole office. So, right now I've only got 6 ADAs that were here prior to 2020 in my office, and that was out of 23 total. So we're experiencing a lot of turnover. The point of getting back to elected DA pay, the point I made was we're trying to keep that 10% higher than the top of the scale. But just for context, of all the states that touch Georgia, elected DAs make the least. And I think that's worth noting. And like I said, we just want one step for prosecution support services. And we have had some turnover there. That's the next slide. But from there, if I may, I'd like to get to 8.35, which is adding 4 ADAs back to the Coweta circuit. We've discussed that before. And the next 8.3.6 is fully funding the newly created West Georgia circuit. And Mr. Chairman, I didn't provide this when we discussed the amended fiscal year budget, but I've given you all a copy of just some caseload data, frankly, in light of the questions you asked last time. And I appreciate this committee's support of that in the amended fiscal year. But I did want to make the point, when we split our circuit, the Coweta circuit, what's left of it, ended up with 7,900 cases, Coweta, Meriwether, and Troup. The West Georgia circuit, Carroll and Hurd, ended up with 3,974 cases. So what I've highlighted here, just quickly, if you break that down by state-paid ADAs, if the Coweta circuit's not given the 4 ADAs back, both circuits would have 8 state-paid ADAs, and the caseload disparities a substantial difference there. So happy to take any questions on that, but I wanted to make the point that if I get those 4 ADAs back, even with local funding, I'll have 19 ADAs, and I'll still have over 400 cases per ADA. So I'm making that request because we really don't have the number of prosecutors to handle the caseload, and this circuit split is just an opportunity to help one circuit, just to be transparent. Like I said, one day I do want to kind of give a shout out to is the new West Georgia Circuit DA, Sarah Japor. She's here. In the amended fiscal year, we decided to use excess PAC funding to cover some of those state positions through the end of the fiscal year. But it's obviously very important for her to get fully funded according to the state statutory formula, which would result in her having 8 state-paid ADAs. The final...
real fast on that,
yep.
So the funding that you have there, is that based on the new step pay, or is that based on...
It's based on the new scale.
The new scale? Okay.
Yep. And finally, we're asking for an additional ADA for the new judgeships coming in Alapaha, Augusta, and Douglas. I heard that that's going to be funded January 1, so I don't know if that affects what our ask is here. Yeah. So happy to take any other questions if you'd like.
And no one was walking out on you. They have rules starting at 11, so.
I figured we started late. I get it.
Yeah, that's right. Any questions? No. I appreciate it. I think you did a good job there.
Mr. Chairman, thank you. Thank you for explaining why everybody got up and walked out on us. I thought it was because I was about to start talking, so I sure do appreciate you saying that. Before I talk about the conflict program, which is 8.1, I just want to give a shout out to the conflict team, who recently successfully prosecuted an aggravated child molestation, charged with aggravated child molestation, and exploitation of a child. They began working on that case last spring. They tracked down witnesses in Alabama and in Florida and successfully ended that prosecution last week. So it just goes to show you that the legislature's commitment to these conflict cases has paid off. I'm proud of what the DAs have done on conflict cases, as well as the Solicitor Generals and the conflict team. So I want to thank you for that. So in the conflict 8.1, you'll notice that we want to increase funds. 8.1.1, increase funds to provide ongoing recruitment and retention for this prosecution support. Also increase funds to provide for the revised pay scale and a step increase for the attorneys, again, to support the recruitment and retention. I think the one thing that we want to add is an additional conflict investigator and a conflict prosecutor. That would be 8.1.3 and 8.1.4. The reason for that, Mr. Chairman, is quite frankly, we have a number of conflict cases in South Georgia, and we're having difficulty finding people to take those cases. And what I would like to do is be able to hire someone to handle those cases in South Georgia. Now, when we took over the conflict program, prior to July of 2022, conflicts were assigned by the Attorney General. On July of 2022, we began assigning conflict cases out. And a conflict case for us would be, for example, when Mr. Cranford has a conflict of interest, either a financial conflict of interest or a personal conflict of interest, and cannot prosecute the case. So in July of 2022, we inherited hundreds of cases from the AG's office that they were not able to find conflict prosecutors. In addition to that, we also had elections that saw a number of DAs lose elections and a number of prior defense attorneys take those offices. So, for example, in Columbus, well, that DA didn't lose. That DA was prosecuted by the Attorney General's office and sent to jail. And so the governor appointed Stacey Jackson, who was a very successful defense attorney, had hundreds of cases. And so we had to find DAs to take those cases, and a number of DAs took on, and as I recall, there were about 200 cases that Mr. Jackson had. We had a number of DAs, Mr. Cranford being one of them, Ms. Mosley being another, Lewis Lamb being another, who took about 40 or 50 cases apiece and went down to Columbus and been moving those cases. But we also had cases continuously coming in, and we've kind of maxed out the DAs based upon their caseload. So that's why we established that conflict team to handle those cases in which the DAs we've already called upon numerous times to take those cases, and we were simply going back to the well too much. So that's the reason we want to add additional investigator and a conflict prosecutor so we can cover South Georgia. We have had some DAs, again, lose elections. These were incumbents who lost elections. They lost elections to defense attorneys. So we've already picked up another 40 cases just the other day that I'm not assigning out to DAs. We're going to take it on ourselves. But that's one of the reasons I'm asking for that.
And I do have a couple of questions. I mean, I can really appreciate that. I think it's important. But once we put them in the big budget, they're there forever. And so I believe that there are ebbs and flows. I think we've talked about this. Hey, there's ebbs and flows of when this happens. And so if there's only so much money, what I have to figure out is, what does PAC need to be successful? And there are more conflicts out there. I think we've talked about this.
Yes, sir.
If you're a DA, uncomfortableness is not a conflict. So be mindful. I know you guys are a lot smarter at that than I am, but there are a number of conflicts that are happening. And a number of DAs are stepping up to fill the void. And I don't know what I'd have to ask the district attorneys, I think, are, would you rather us fund your staff and you guys continue to step up and you continue to go to that well for conflicts, or that's kind of like the position I'm kind of I'm in, I think, on
That's
it.
a great question, and I think I can answer that. My preference is that the DAs be able to take on more of these cases as we fill these vacancies that they have, and that we get out of the conflict prosecution program. When I say I don't mind doing the appointments, but I would eventually like to scale down our conflict team. And one of the things I told the legislature last year when you funded the conflict team was eventually we want to get out of that special prosecution division and give it back to as many as we can to the DAs and to the Solicitor Generals. I think that's a fair question. The only reason that we are in the position we're in now is because of all the hundreds of conflict cases that came in, and we've tapped out these DAs. We've simply tapped them out. But I do think that's a fair question, Mr. Chairman, and I do think I would like to eventually not have a conflict prosecution team.
Fair answer. I think, we'll work through that, but I do think, if you're DA, I want to make sure we're taking care of you and your staff. And so, there's only so much. So that's kind of, please continue to step up. Does it have to be an elected district attorney who does the conflict? Can it be an ADA?
Oh, no.
Can it be, I think a solicitor could step up for a federal case for a felony case.
Yes.
Theoretically too, right? So
to answer your question, we appoint the DA, but 99.9% of the time, the DA designates an assistant DA, or the Solicitor General designates an assistant DA to go down there. Now, for example, Lewis Lamb, who's got some vacancy problems, he's handled a lot of the conflict cases himself, but typically what'll happen if I assign a case to DA Cranford, he'll assign one of his senior assistant DAs as his designate to go down there and prosecute cases. Part of the problem, quite frankly, is just the travel and the circuit and trying to find prosecutors that can go to neighboring circuits. Because if you're looking at, for example, again, South Georgia, where the DAs are having vacancy problems in that area, and then we've already tapped them out on a number of other cases, just trying to get somebody down there. But those are all fair questions, Mr. Chairman, and I completely understand. Our goal is eventually not have a conflict prosecution team.
Okay.
And when we hired our conflict prosecution team, they knew that. We explained that to them. We're here to take on this overload. Eventually, we're not going to have this team, simply because it doesn't make sense.
Right. Okay. Any questions? All right. I think we're good with 8.1.
Okay, and then if you go to the Prosecuting Attorneys Council, 8.4, again, increase funds to provide for recruitment and retention of prosecution support, increase funds to provide for the revised pay scale, and again, to keep the attorneys. I have 12 resource prosecutors. That is, for example, many of you are familiar with Sheila Ross, who does capital litigation. I have Lelaine Briones, who is the deputy director, who also does sex crimes and gives advice to attorneys and DAs when they have a question. I have John Reagan, who does gang crimes. I have Charlotte Jackson, who does domestic violence crimes. And Will Johnson, who's back here in the back of the room, elder abuse and juvenile crimes. Not only are these resource prosecutors who train and are available to the DAs for assistance, but they also have taken on some conflict cases where we've sent them to other counties to prosecute cases. Will Johnson's a perfect example, elder abuse. Those are complex cases, and many of the DAs have used him as a special prosecutor, again, when they're short-staffed or when they don't have the experience. So that's the purpose of that, those funds. Now, the biggest item, 8.4.3, increase funds to support tracker case management. You'll see that we're asking for $1 million there. The reason for that is tracker is used in almost every, I think it's used in every judicial circuit. It's also used by Solicitor Generals. It is a case management system. But what has happened is, since we've developed tracker, is body cameras, e-filing, all the technical improvements, technology that has improved, we haven't been able to keep up in tracker, so that's why we're asking for that $1 million. I will point out that $690,000 of that is a one-time need in fiscal year =26, and we won't be back to ask for it again. The rest of it is to support large data filings, videos, phone dumps that are now happening. The files are getting bigger and bigger. Mr. Cranford mentioned when he was an assistant DA and I hired him. I started prosecution 40 years ago. Your file was in typically a folder like this. Nowadays, they are getting terabytes and large electronic files that take up a substantial amount of memory. And so that's why we're asking for that, Mr. Chairman.
And I do have a question related to that. So Supreme Court's working through case management system in the hundreds of millions of dollars. What's the impact of that? I want to fix your management system, but I also don't want to waste the resources to fix it. So what's the larger?
There are two things. So there's the case management system that AOC is working on. I've already talked to AOC. We want Tracker to be a part of that. Two things are they're looking at a different type of case management than the DAs are. Obviously, more of an internal case management for the DAs, but we want to be able to talk to each other so the judges will know what an accurate case count is. Mr. Cranford also knows a little bit more.
Yeah, Justice Boggs appointed me to the committee I think you're talking about, and thankfully he allowed me to designate the person, Jay Harrell, that kind of created Tracker. So I attend when I can. Jay always attends, but yeah, the point in coming up with kind of a uniform system for clerks and everybody, they invited us in because I think a lot of judges know Tracker's a really good program, and so the intention from the beginning, I think from Supreme Court on down, was for Tracker to be able to work with what their goal is and to be part of that. It really is a good program. I mean.
Okay.
And finally, Mr. Chairman, you'll see that, well, not finally, but 8.4.4, I'm asking for Deputy General Counsel. And this is a position to assist me based upon all the duties that I'm currently assigning not only to the deputy, not only to the general counsel for PAC, but to other attorneys in my office as well, taking them off of what they should be doing. But just to give you just a brief example of what the general counsel does for PAC, and I know y'all see him up here during the legislative cycle, those 40 days he's up here a lot. But also he has worked on 20 amicus briefs over the past 5 years for the DA's Association and the Solicitor General's Association. Also, we get requests from the Georgia Supreme Court for amicus briefs. We handle civil lawsuits. When I say civil lawsuits, we kind of manage them, making sure that we're working with DOAS. If the Attorney General chooses to represent us, we're working with the Attorney General. I think you heard earlier that the Attorney General is in the executive branch, and he considers it a matter of professional courtesy whether or not to represent someone in the judicial branch. Moot court and appellate arguments when we have to argue in front of the courts, charging documents, extradition requests, just a number of issues that I am having to assign to other lawyers. When I took over as executive director, I combined a bunch of positions. For example, the deputy executive director is a position combined with prosecution support. Lelaine Briones does both, so I could create the gang prosecutor unit. So that's what I've been doing, but we really need some assistance in that field.
All right, do you have a question related to that one?
Yeah.
Vice Chairman Kelly. Thank you, Mr. Chairman. Pete, again, appreciate the work y'all do, that the council does collectively and our DAs do individually. But again, I think you've kind of heard the chairman kind of say, we're dealing with some limited funds here. As we're prioritizing, should we prioritize that $260,000 towards pay raise, scale increases, or should we prioritize a new deputy general counsel?
Prioritize pay increases, sir.
Okay, thank you.
The people that work there now more than have earned that, so I appreciate that question. Last but not least is provide one victim advocate. We do have a statewide director who assists all victim advocate positions across the state in Solicitor General's offices as well as DA's offices. However, because we've taken on some of these conflict cases as well, and we are doing special prosecutions, her time has been divided, and we need a victim advocate to help assist her and to assist the DAs and solicitors. I'll also point out, in many of you may be familiar with the crisis response team that ended up going to Bartow County when the high school shooting occurred.
Yeah,
Barrow, I'm sorry. Yeah. Thank you, Mr. Chairman. In Barrow County. And that crisis response team was organized through PAC, and we called upon a number of DAs and Solicitor Generals to send their victims down there, their victim assistants down there, and got a number of positive remarks about it. So we also do the crisis response team. And I've taken up too much of your time, but I'm here to answer any questions.
That's right, yep. That's Vice Chairman said that is important work, and we appreciate everything that PAC does and their district attorneys do to keep us safe. Any questions from the committee?
Thank you, Mr. Chairman.
Thank you.
Thank you all.
And next we'll have PAQC. It's 8-5. Hello, sir.
Morning, Chairman, and two subcommittee members.
Very important members, though, so we're ready to go.
I realized when they all walked out that nobody wanted to hear what I had to say. But
no, there's rules. They just, they serve on rules, and that's an important committee as well. But this is the reason we record it, and they'll ask a lot of questions as we get into some of the other meetings related to it. So
10-4. My name is Ian Heap. I am the Executive Director of the Prosecuting Attorneys Qualifications Commission. I appreciate the opportunity to come up and speak with you. I know your time is important, so I'll keep this relatively brief, although I will answer any questions as we are a new commission. Our budget request for 2026 FY is, we only have one item, that is your sheet 8.5.1. We are asking for an additional $80,000 to cover the difference in anticipated administrative costs and the administrative costs as they have appeared.
Fair enough. Any questions from the committee? Vice Chairman Kelly.
Thank you, Mr. Chairman. When you say anticipated administrative cost, what are you talking about that you're paying to PAC currently?
Well, when I say anticipated, I didn't create the budget or the initial appropriations. The initial appropriations were in fiscal year 2024, but we couldn't get going in 2024, so whatever. But that number wasn't just pulled out of the air. That number was based on the JQC, who spoke earlier, and we're patterned largely after the least organization. And so they used a number, you used, I guess, a number based on a prior JQC budget, which anticipates spending money on things. Well, because it is a small, it's not even an agency, it's a program. Since it's a small program, we can't do our own accounts payable, accounts receivable, purchasing, and HR because each one of those has to be handled by a different person to avoid potential fraud, et cetera. So as you're fully aware, smaller agencies or groups are attached administratively to larger groups. The JQC is attached to the AOC, the Administrative Office of the Courts, and they spend $32,000, or they give the AOC $32,000 per year to handle their administrative costs, like I just explained. Interestingly enough, that includes IT support, website, et cetera.
So they're at 32. What are you being told so AOC is administering the JQC for 32 grand?
Correct.
What percentage of their budget is that? Do you know?
It's probably about 3%. I'd have
And
to guess.
what is PAC saying that they want to charge y'all to administer?
Well, it's not what they say they want to charge. It's 10%.
Okay, 10%.
And when I started, I was hired. My first day was August 1st, so we haven't been in operation very long. I started to get going, and when I started asking about how to spend money, I was informed that it all had to go through them, and they explained that they would charge 10% for that, and I didn't really agree with that. And we had some negotiations, and I reached out to a lot of people and talked to a lot of people, and ended up signing an MOU after bringing it to my investigative panel, who I work for. I mean, director, executive director, whatever. I'm an employee, okay? And I work for the commissioners, who are, again, appointed and not paid. I work for the investigative panel. I brought this to them, and they said, if that's the only way we can get going, sign that MOU, and we'll see what we can do in the future.
Yep.
We're going to help you see what you can do on that in the future. 10% is unacceptable. And we want to help you with that. We understand that's not your problem. We're going to work on that for you, okay?
Just one last. How many employees are under paid employees, I guess?
Employees are 3.
Okay.
And we handle all our own IT, which is what I brought up earlier with the AOC. We set up our own website, and I'll break my arm patting myself on the back. It's a good website. We run our own email. We run our own servers, everything.
Sure. Any other questions from the committee? Appreciate you being here, and appreciate your time.
Thank you. I appreciate it.
Thank you.
Very kind of you.
And we have the Public Defender Council. I'll pass it.
Good afternoon.
Hey, how are you? Still morning, I hope. Yeah.
Is it morning?
Yeah.
Okay,
Feels
that's
like
a good
afternoon,
thing.
doesn't it? Yeah, it does.
Good morning, Chairman and other members of this body. Good morning to all of you. Thank you all so much for allowing us to come back to present to you and to hopefully explain to you what it will take for public defenders to be successful and for us to be the other side of the coin for the prosecutors, so that we can continue to buy value for our taxpayers and for you, our funding source. Our budget this year is kind of flat, with the exception of 3 items. Most of the items that you see in there, they just pass through. Increased funds for teachers' retirement, reflect an adjustment to agency premiums. Those are just pass through. So I'm not going to really waste your time to talk about that. I think I'm going to go to the what we're really asking for. But before I do that, if you would indulge me to take a few minutes to correct the misunderstanding that we're making more money than prosecutors. We are not. The 72,000 that you see, as I explained to you, Chairman, when I met with you, is inclusive of all supplements. So when we got, in 2023, when we got those appropriations, we started on the journey of providing equity amongst all our employees, especially for those in the rural areas. So we did that equity to make sure that irrespective of what supplement you get, we're starting at the same level. So when we got the money and we increased everybody's salary from those two appropriations that we got, I think it was 2023, we considered all supplements. Ours is the ceiling, theirs is the floor. And what I hope, and when we met with you, you had asked for a compilation of all the supplements, and we have provided that for your office. So I think right now, we're not even comparing apples to oranges. I think we're comparing apples to chicken right now.
I will say I'm not going to defend them. What I will say is that we need you and them, so the public defenders and the prosecutors,
yes, sir,
to have the same pay, starting off through the steps. And so I know you guys have been working with PAC. I know PAC's been working with you to try to you guys to create an agreement and an alignment with the steps of pay.
Yes, sir.
I need you guys to work harder, and this is if PAC is still in the room. They need to work harder because we need that parity. When we don't have it, there's a lot of angst on our side because now PAC is asking, or district attorneys are asking for more money. I understand you're going to say they don't. We've cannibalized some positions. We've made our place more efficient, but we do need those. We need that parity. So please work hard, PAC. Please work hard, and I'll tell the PAC members, let's get to where we're all in agreement about what that looks like. That makes our life a lot easier,
yes,
and ultimately, and when our life is easier, your life is easier too. I promise you. So go ahead, proceed with that.
Absolutely, but I don't want us to start from a misunderstanding that we're making more money, because then we'll come back to you at the same point. And I think it's just a misunderstanding because they see 60,000, but the 60,000 is not inclusive of all supplements. Ours is, and so until you get the information from both of us to see where we are, I want you to increase the money for them. I don't have a problem with that because it helps with retention and with us to be able to recruit. But if we start on a misunderstanding that we're making more money, then it makes it such that we're never going to get to the point where we need to be. And to your point, we are two sides of the same coin. And all we're trying to do is make sure that we buy the best value for the taxpayers. We're not there, and that's what I want. I want to make sure that we correct that before we go. And we have provided for you the salaries of all our CPDs and the supplements as you requested the last time. And I think that's going to really help to determine who's making what. And I agree with Mr. The Coweta CP District Attorney. My life is all about CPD. District Attorney, that we need more money. We all need more money, but we need to be at the same point. That's what I'm saying. So one of the things that we're asking for, Chairman, is the increased funds for Juvenile Conflict Division Manager position. And as I explained the last time, that is our effort to bring some of those conflict cases back in so we can afford it. It's a cost, we need to be more cost efficient. And if we have a manager in, we dispatch him to all parts of Georgia, and the only attorney that reports to him. And so that, because juvenile cases have very short timeline, we want to make sure that we have someone that's readily available to take these cases, and we are not paying per diem. We would love to pay per diem. We appreciate our contractors. They've always been there for us, but it's getting to a point where it's becoming more and more it's not that cost efficient anymore. That's why we're asking you to please approve that.
Let me ask a question on that. So outside of the Juvenile Conflict Division Manager, you also have just an Adult Conflict Division. I think that was funded. So when it was initially funded, it was somewhere, and I wasn't on this committee, it was somewhere in the ballpark of $2 million. Yes. Do you have an idea what that looks like today, what the amount is for that today? Is it $8 million somewhere
that-
near that ballpark?
We use that to fund 8 regional offices, and we're still going with that. So that's been funded. We only have about 14 of those. We really seriously should have about 22 of those, but we're seeing what we can do with 14 so far to make it.
Well, what's the funding? If we started off with $2 million a few years ago when it started, do you know how much is funded today?
It's about 8 million now.
So it's increased 400%, right?
Yes, and because the cases keep increasing too.
Have the cases increased 400%? Maybe they have.
Absolutely. The cases are coming in droves. I cannot tell you specifically what the numbers are, but in my typical fashion, I'll get the numbers correctly and I'll send it to Ms. West.
Okay. Because I think that's really where the rub is we want to make sure it went from 2 million and all of a sudden we're funding 8 million.
Yes,
and so where does this go if we fund this position? Where do we wind up? In 3 years from now, like we wind up. I don't imagine. I think when it was sold was, hey, there are conflicts, and as soon as we get these conflicts out, this is not going to grow. This is actually going to go away. But then we're hearing it's $8 million instead of kind of going away to get that rush of conflicts out of there. So
absolutely, I would like for it to go away too. And we're not responsible for the indictment. We appreciate the prosecutors for doing their work, but we'll also like to be able to do ours as well. And so the cases are growing, and we're getting them in leaps and bounds. I mean, we are just getting more and more cases. Gang and RICO, regular conflicts, and it doesn't matter what we get. We stand to provide the services according to the statute. And so as much as I want to talk about why the conflicts are growing, it's not within my power to do that, but it's within my responsibility to make sure that we're there to meet the mission and the statute where we're supposed to be. And what we're asking you for the juvenile is because the juvenile cases have such a short timeline. We want someone in place who's going to train on the SB 440s, someone who will be there to be dispatched to where the legal deserts where we don't have attorneys. And when we say we have legal deserts, folks think, what is that? There are places where we don't have attorneys, and we want to be able to make sure that we can meet those timelines. Someone who can train on juvenile advocacy throughout the state of Georgia.
Right. So, and you had that. So the amended budget funding went away, but you have someone staff that position today.
Yeah, because that position was put in place, I think it was in 2020, and then it went away. Right. And so we're struggling with that to continue if we have salary savings. And back in the day, we used to have a lot of salary savings because we had a huge vacancy. We don't have that anymore. So it's becoming more and more of a problem. I think our vacancy rate today, the last time I checked, margin of error 3%, maybe we have about 3% now.
And related to that too is the qualifications. I know we've asked you a number of times about how does someone qualify for a public defender, and I'm gonna paraphrase, so this is not a direct quote, but basically, you said if they come in and they ask for help, they probably need the help, generally speaking. And so, yeah. But there is law on the books on how to qualify, and I do believe most of the public defenders who work for you do have pretty stringent qualifications that they're going by today, based on salary and validating. I think even the question was posed to you. Are you validating check stubs and payment? How much money these people have that are getting the services. It sounds like your team is validating a lot more than you said they were validating, and that's a good thing because it's worrisome when you say we're not really validating the pay stubs. And so,
well, maybe I didn't say it though. Maybe it didn't come out right. We're following the law. There's poverty guidelines. What I said is once they tell us what they do, if they tell us I think my example is someone works at McDonald's and is making the minimum wage. If that's truly where they work, and I hate to say McDonald's, so I'm not offending anyone, then there's not that much validation. But are we following the rules? Are we following the law? Yes, we are. And to your point, when you brought it out the last time, I have taken a big look at it. We are reviewing it to make sure that we can submit another approval because it has to be approved by our council. A lot has changed since the last approval. We're working on that. Once I get the new summary, then I will send it to Ms. West so that you can have it. But are we following the laws? Yes. If it came out that I said that my team is not following the law, that was not what I was saying. I was saying to you that sometimes it's just very easy to know what someone is making, that we don't have to go the extra step.
Okay.
Yeah.
Any questions from the committee? All right. So we've talked about juvenile conflict division. I've drifted us into the weeds, a few other positions. Anything to add on the 3724, which was the division manager, the juvenile conflict division manager?
No, sir. I just respectfully ask that you put it back on the books like it was there before.
Okay. 3725, 26, and is really, I guess, really 27 is related to the new circuits, right?
Yes,
and one circuit that failed.
Yes, thank you for allowing me to address that. I think Mr. Cranford addressed that effectively to the extent that they're going to get those small positions. We want to make sure that we are there to represent the clients, that they seem to me what he's saying is that we're going to expedite prosecution. We're going to be prosecuting more. To the essence of that happens, we have to have the staffing in place to do that as well. And so we're asking you, if Coweta is going to get 4 more attorneys, we ask for the 4 more attorneys. Is West Georgia is going to get 4 more? Because what's going to do is, if we're not there, then we're going to have more of a backlog. And I've been trying to follow the history of backlog for my 37 years or 36 years of being with criminal justice. It keeps changing. And we have to do what we can to make sure that we can halt it. As public defenders, we're going above and beyond the call of duty to make sure that we can put some initiatives in place that's going to help us to reduce the backlog. One of them is sending young people back to school when they leave the criminal justice system. One of them is what we're doing is juvenile justice. Because juvenile justice is just a manifestation of everything that you see in the adult court. If you don't take care of that, we're always going to be fighting against the tide. And so we would like to be there in West Georgia. We would like to be there in Coweta to make sure that we have adequate staffing to meet the prosecutor's demands. And so I ask you to do that.
Fair request.
Thank you.
Anything from the committee? No. All right. I don't think we have anything. Only thing I do want to stress is with PAC and with you guys, please get a plan together for salaries on, a salary structure. It's really important to us.
We have been working on that, Chairman.
And however I can help. I mean, if I need to have it in my office and get you guys all together, I'm happy to lead that effort. But at the end of this, by next year, we do not want to hear that we don't have that figured out on either side. And if there's a hindrance, and whatever that is, we'll sit in my office and we'll figure this out for everyone. So that's on both sides. That's for PAC too. That is highly important to us.
And we will continue to work on it. I had a long conversation with Mr. Skandalakis about this 2 weeks ago. I would like to share with you a timeline of what's been happening over that. Respectfully, you all paid for a 2016 study that was done on this issue in 2016. We don't have to revamp the wheels. We just have to get together. We are going to have a scale effectively before. My goal is just, I'm hoping that we can join the prosecutors in doing that, because it only makes it works better when we can work together. I want to share with you a timeline of what we have done in the past, and we will repeat the timeline, and we hope that our prosecutors will join us to make sure that we can do what you're asking us to do and what the senators asked us to do 2 years ago.
Right. And we appreciate that. Yeah, I'll take that timeline. And again, if I'm gonna have to follow up. I'm gonna follow up every month, and if there's problems before we get into session next year, we're gonna have this figured out. And so, raise your concerns to me if there's problems. Pat, raise your concerns to me if there's problems. But this is going to be figured out before next year. We're working towards it. We're going to figure this out. We have 8 months basically to figure this out. So, by the time we're out of here.
I have one more request.
Yep.
And I thank the prosecutors for bringing to bear the issue that we're still struggling with retention and recruitment. I appreciate they put the numbers out. I would just like to put our numbers out per code. And ours is actually is much less than theirs because they have more people. Ours is only $5.3 million to get up to code. And we respectfully ask that while you're considering their request, that you consider ours as well according to the code. And not just the code, to make sure that we can continue to have the low vacancy rate we have and to continue to retain and recruit, because until we can do that, the other side of the coin is not going to work, and that's what's feeding the backlog.
Okay. All right. Thank you so much.
Thank you so much, sir.
Appreciate you.
You're very welcome.
And for the members of the committee, we'll also, Ms. Deborah Stokes wants to come and talk to us just briefly from the Georgia Council on Aging. Is she here? Yeah, there she is. And you can do the podium or you can sit in the chair, whichever makes you more comfortable.
I can use this because I will be very brief. I just wanted to state regarding the request that we have as a co-age priority. I'm Executive Director of Georgia Council on Aging, and you're all familiar with how co-age works with people across the state to determine some of the issues that can be addressed through funding or policy. So I put in your notebooks a sheet explaining our request for a multidisciplinary teams coordinator to cover the entire state. As Mr. Skandalakis mentioned, when there are organizations and cooperation within the prosecutors to pull together all of the parties who are needed to prosecute these crimes, it helps. Particularly, there are already MDTs for child abuse and neglect, and we simply, as an organization, are asking for your support in creating a coordinator position to handle this for elder abuse and exploitation. All of our co-age partners and stakeholders are on board. We started this request 2 years ago, so we are still at it, and we think it's a valuable and a viable reason for that funding. Thank you so much.
Today there are five circuits.
Five circuits
who are using it. The goal is to get more, right? And so
exactly. And we would like that coordinator to be able to support those 5 circuits and collect data on the impact of having those MDTs in place so that other circuits within the state are encouraged to set up their own MDTs.
Right.
Thank you.
Fantastic. Any questions from the committee? Thank you for being here. Appreciate your comment. All right. With that, our meeting is adjourned.